Okay, we're back. I'm Randy Critical live on the fly here, and we are going to Zurich right now, or somewhere in Switzerland, being joined by phone by Nils Melzer, the UN Special Rapporteur on Torture. Welcome to this show again, I think 2 weeks in a row, Mr. Melzer, Dr. Melzer.
Just call me Nils.
Okay, I'll just call you Nils. I've gotten to know you that well. Nils, we were talking in the first segment with Steve about just on Friday, the UN working group on arbitrary detention came out with, I don't know if it's a statement or a finding. Can you tell us what it was and the significance and what it implies?
Yeah, maybe briefly, obviously I'm not part of that working group, but, as it's the weekend and, you couldn't get a hold of them, I can perhaps, so I cannot speak on behalf of the group, but I can speak on behalf of the system because I am the UN Special Rapporteur on Torture. And in terms of status, it is very comparable. We're all independent UN experts. We're all appointed by the UN Human Rights Council in Geneva, which is a group of 47 states on a rotating basis. The US has been a member in the past and is today an observer, has returned to the Human Rights Council early this year after under the Trump administration. They had left the Human Rights Council, but in February, the Biden administration has recommitted to that council. That's important because states that are committed as observers or as members are politically obliged, not legally, it's not a treaty obligation, but politically bound basically by the systems and procedures established by the council. And so all of this is important because the working group on arbitrary detention, just as my own mandate as the Special Rapporteur on Torture, are human rights mechanisms that have been established by all of those states together in order to report to states whenever they have allegations on violations of human rights. And the point of this procedure is to draw the attention of governments to possible violations of human rights under their jurisdiction and to get them to take countermeasures to remedy that situation. And so how that works is that those experts, in this case, the Working Group on Arbitrary Detention, receives allegations from their sources, and then obviously they make sure that these are credible allegations, and then transmit those to the government and request the government to take position on that. And that's what has happened in this case. The US has not responded at all to
wait
those
a second,
allegations.
Nils, I want to stop you there. Just one point, somebody goes to them, the plaintiff in this case, would it be Steve Donziger or somebody else that would show them something? How does it initiate?
Yes, it can be. It could be Donziger in this case, but it could also be a human rights organization. It can be a civil society organization. It can be anybody actually that has reliable information on human rights violations. It could be witnesses, anybody actually, that even other states, if they have received reliable information that can. So that's a very informal procedure. And the point is also that these allegations that are being transmitted are not necessarily already an established fact. They are allegations. And states are then invited to respond to those allegations, perhaps correct them, provide evidence, and on that basis, then a certain conclusion could be found. And in this case, this information has been brought to the attention of the working group, and they have transmitted their concerns that the detention, the home confinement of Stephen Donziger for I think more than 2 years now, that violates the prohibition on arbitrary detention, and they said that on the basis, as I understand, that that first of all, pre-trial detention is an exceptional measure that can only be taken when there is a real flight risk or a danger could emanate from a suspect in a criminal case if he's not being physically secured in custody. Now, in his case, there really is no basis to order a pre-trial detention because clearly he's never been violent, and there is, not even the court ever claimed that there would be a physical risk or a threat emanating from Donziger. So the only risk that they raised or claimed existed was a flight risk. Now, he had never missed a court meeting. He had, he lives in New York City, for more than 14 years with a wife and a son. There is no reasonable, it's not plausible to think that he would abscond if from a criminal proceeding where the maximum punishment is 6 months of confinement. And he has actually already spent 4 times as much in confinement now, which again is a clear violation of the principle of proportionality. So all of this to say, the concerns that were raised by the working group were that, well, first of all, there seems to be a clear bias on, and I'm now citing, referring to what they have found. I have not investigated the case myself, but I'm just recounting it, that they found a clear bias on part of the involved judges, where they have, circumvented basically even procedures to appoint judges that are impartial, that they tried to make sure that the case arrives with judges that would decide as was desired, in this case by Chevron. And there seem to be strong indications in that direction that Stephen Donziger has been abusively basically being confined in house arrest because there is no need, there's no necessity to do that. And because according to human rights law, when pretrial detention exceeds the maximum duration of a possible prison sentence, then in fact the sentence has already been served, despite the fact that there has been no conviction. And the Human Rights Committee has repeatedly said that in such cases, the defendant simply has to be released. It becomes disproportionate and excessive to use these types of measures. So that was also one of the concerns they had. And then one very important concern is that they said they had a strong impression that this proceeding was being used, and the confinement was being used as a reprisal against Donziger, who has, and this is important to underline, the reason he is involved in all of this is because he acted as a human rights defender, as an attorney of the indigenous people of Ecuador, who had suffered incredibly under decades of pollution caused by Chevron, and there seems to be abundant evidence for that pollution and the accompanying risks. And so that it seems to be that that this proceeding should serve as a deterrent and as a reprisal against a human rights defender, which in itself obviously is a human rights violation. And so this is really kind of the gist of that opinion. It is not a judgment because the working group is not a court, it's not a judicial instrument. It's a mechanism, as I just explained before, that was established by the states, and mandated to report these types of allegations to them. So, states cannot, in good faith, then not engage with the mechanisms they have, that they have established themselves, which unfortunately in this case has happened with the U.S. government. Perhaps I can just say that I've made the same experience with the U.S. in my intervention with in the case of Julian Assange, that I received a very short response, and then the U.S. government basically refused to engage. But that was under the Trump administration. And so there was great hope when President Biden declared in February this year that the U.S. would re-engage with the Human Rights Council, that as an observer. that this would change, because he said, and here I basically quote from the press statement by Secretary of State Blinken, where he said that the Human Rights Council can serve as an important forum for those fighting injustice and tyranny. And here we clearly have indigenous people fighting for justice for decades of grave abuse. And then he goes on, this press statement by Blinken, to say that the council can help to promote fundamental freedoms around the globe, including fundamental rights of marginalized communities, including, obviously, this would be the indigenous people, and that the US must be at the table using the full weight of our diplomatic leadership, it says. So all of this would suggest that the US claims a leadership position in human rights, and this is simply incompatible with their refusal to engage with the working group on arbitrary detention in this case, and also with similar mechanisms in other cases.
Well, you made a good point. You made a lot of good points. But early on, you were talking about he has spent more time than the 6 months that he received, which is the maximum, 780 days. If he had pled guilty the day he was charged, he would have been out, 600 days ago. 600 days ago. So he's really serving the 6 months on top of the 2.5 years almost, a 3-year prison sentence for something that carries only 6 months at most, minus good time. Now, what are the recommendations by the working group on arbitrary detention in this case? Now, what are they recommending that they do? I think it's compensation and what else?
Right. Well, the working group came to the conclusion that in this case, it regretted, obviously, first of all, the failure of the U.S. government to engage constructively with the working group, to engage at all with it, and so they said, based on the evidence at their disposal, they came to the conclusion that in the case of Stephen Donziger, the Universal Declaration of Human Rights, as well as the International Covenant on Civil and Political Rights, had been repeatedly violated, and this, particularly in terms of the prohibition on arbitrary detention, on due process as well, very important, and on the prohibition of discrimination. So these are kind of the three big, human rights violations that have been spotted. And so the working group says that, and here I quote from the decision, the working group requests the government of the United States of America to take the steps necessary to remedy the situation of Mr. Stephen Donziger without delay, and bring it into conformity with the relevant international norms, including those set out in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. And then I continue in the quote one more sentence here, where it says, the working group considers that, taking into account all the circumstances of the case, the appropriate remedy would be to release Mr. Stephen Donziger immediately and accord him an enforceable right to compensation and other reparations in accordance with international law, end of quote. So this is what the working group has asked. And then it has also asked, actually, the third thing it has asked is it urges the government to ensure a full and independent investigation of the circumstances surrounding the arbitrary deprivation of liberty of Mr. Stephen Donziger. And that's very important, because those due process violations seem not to be accidental, but the result of a pre-existing bias. If that is confirmed, that would actually be a case of judicial corruption, which clearly must be investigated to make sure that this is being treated according to the law. And so this is kind of the core of the decision. And there's also a follow-up procedure where the working group asks both the sources that have submitted evidence and the government of the United States to provide it within 6 months with information as to how that follow-up, what follow-up measures have been taken to its recommendations, whether he has been released unconditionally, and if so, on what date, whether compensation or other reparations have been made to Mr. Stephen Donziger, and whether an investigation has been conducted into the violation of his rights, and if so, the outcome of that investigation. So, and also finally, they also want to know whether the US has made any legislative amendments or changes in practice to harmonize its laws and practices with its own international obligations that are derived from the treaties that the US have ratified. So it's not, a working group pulling this out of thin air, but they're really, these are some of the most established international experts, legal experts that have been appointed by the states, So it's not some NGO making some wild claims. And I'm not trying to belittle NGOs, they're extremely important, but the governments can more easily distance themselves from claims made by NGOs than from claims made by mechanisms they themselves have appointed. That is basically a bit the summary of this.
Well, thank you, Professor Melzer. My associate Kelly Lane pointed out earlier to me that the judge in this case called this working group connected to Stephen Donziger. Could you give me your thoughts on that in a minute or so?
Well, I think that, as far as I understand, any reference to the United Nations was avoided. But that is also something, that we have seen in other countries. In the United Kingdom, when the same working group decided that during Assange's detention or confinement in the Ecuadorian embassy was a form of arbitrary detention because he was not able to leave the embassy without exposing himself to grave violations of his human rights. In the British Parliament, there was basically claims were being made that, well, this is just some group of independent experts that have no relevance whatsoever. But that obviously happens only when the decisions and the opinions of that working group are not consistent with the opinion of the government, what it would like to hear. Whenever those decisions go in its favor, then these governments are always full of praise for the working group and say that these are the most highly esteemed UN experts. So clearly, what we see here is a politicization of these mechanisms by the states. It kind of basically the pick and choose approach. We use them, instrumentalize them when we like what they say, and when we don't like what they say, they are simply independent experts that no one, that we can simply ignore. That is unfortunately a bit the weakness of these mechanisms, but that's not the fault of those experts, because it's the states that have created those mechanisms precisely in that way so they can play this game. Wow. It's just the reality that is very familiar to me as well in my own work.
Well, Professor Melzer, on short notice, I want to thank you. As you said, I needed somebody right away. I couldn't get through to anybody else as part of that working group. And I think you've cleared everything up here. And I wish you well and look forward to having you back on, because you're always a great guest. And we'll talk to you soon. We're going to take a quick break and come back with the legendary composer and super activist Roger Waters, who's been involved in this case as an activist for many years. We'll be right back.